Hello students, there is a good news for you. Now you can write the same matter at different speeds. Link of the same is given in the description box. Thank you.
Start. Learned advocate for the petitioner submits that the petitioner has been given a clean acquittal by the competent criminal court and not the benefit of doubt. Stop. The criminal case against the petitioner arises from the same incident, same set of facts, and the same allegations as that in the departmental inquiry. Stop. After considering the evidence before it, the criminal court came to the conclusion that it was not the petitioner's duty to pay the bills. Stop. The respondent department had not issued any duty list before the criminal court and had thus failed to establish that the petitioner has committed temporary misappropriation of the amount or that there was delay in the payment of bills to the telephone department. Stop. It is further submitted that the criminal court has further concluded that it cannot be said there was any delay in the payment of bills as the telephone connection was not cut off. Stop. Once the criminal court has ruled that the case against the petitioner could not be established by the respondents and the petitioner was acquitted, the departmental inquiry on the same set of facts and evidence could not have proceeded and no penalty could have been inflicted upon the petitioner, leave alone a major penalty. Stop. Para. In support of the above submission, reliance has been placed upon the judgments. Stop. It is next submitted that the inquiry officer has held the petitioner guilty only on the ground of alleged confession made by him regarding the temporary misappropriation, but has not referred to any evidence against the petitioner or given a single reason for arriving at such a finding. Stop. The disciplinary authority has also not given any reason in support of the impugned order of penalty and has failed to give sufficient weightage to the judgment of acquittal passed by the criminal court. Stop. The order of the disciplinary authority is based on presumptions and doubt regarding the integrity of the petitioner without there being any evidence to this effect. Therefore, under such circumstances, no major penalty could have been imposed upon the petitioner. Stop. Para. It is further submitted that temporary misappropriation of government money is not an offence of corruption. Stop. The petitioner had ultimately deposited the money towards the telephone bills, though belatedly. Stop. Hence, as no financial loss has occurred to the respondent department, a major penalty could not have been imposed. Stop. Para. It is next submitted that the alleged admission of the petitioner before the inquiry officer would not come in his way as he was not in a fit state of mind due to the illness of his wife. Stop. As soon as his wife recovered, the petitioner paid the amount of the bills. Stop. Looking to the nature of the allegations, they do not warrant a major penalty. Stop. The penalty is disproportionate to the alleged misconduct. Therefore, it ought to be set aside or, in the alternative, be reduced. Stop. Para. Regarding the regularization of the suspension period, the learned advocate for the petitioner has submitted that as the criminal court has acquitted the petitioner of the criminal charges, the period of suspension ought to have been regularized. Stop. In any case, The order of regularization of the suspension period ought to have been passed at the time when the suspension of the petitioner was revoked as per Rule 70 of the Gujarat Civil Services Rules 2002 stop. The suspension of the petitioner was revoked on 27/12/2005, whereas the impugned order rejecting the petitioner's request for regularization of the suspension period was passed on 21/2007, and that too after the petitioner made an application in this regard stop.